On behalf of Citizen, Consumer and Civic Action Group, I extend a very warm welcome to this August gathering. It's our pleasure to organize this conference to mark World Habitat Day. As you all may be aware, projections about urbanization is staggering. 65% of the world's population already live in urban areas, and by 2050 this is predicted to rise to 68%, with almost 90% of the growth proposed to happen in Asia and Africa. As policy interest in urbanization grows, there is a real opportunity to bring together perspectives from urban planning and governance. Interdisciplinary and multi-sectoral action will be key to ensuring that our cities are not only resilient, but also safe and inclusive spaces for all. World Habitat Day serves as a reminder for the need to reflect on this challenge and collectively introspect a way forward. Since independence, various attempts to enforce and institutionalize the rule of law in Indian society have not achieved the intended results. While the normative framework of constitutional governance is established through the Constitution of India and the various institutions established under it, deeply embedded values of constitutionalism have not really taken roots in the Indian society. In our first session, our speakers will shed light on a slew of problematic amendments, exclusionary processes, and interrogate the reasons and conditions that have made possible the consistent denial of the commitment given by the 74th Amendment. Please join me, ladies and gentlemen, in welcoming Ms. Meenakshi Kapoor, Mr. Matthew Idiculla and Ms. Shweta Wagh for our session on rule of law and democracy, where our speakers will endeavour to help us understand the interplay between law and democracy in a context where urbanization and inequality are concurrently on the rise. Meenakshi Kapoor is a senior program manager in Namati, a global movement of grassroots legal advocates who help put the power of law in the hands of people. At Namati, Meenakshi works in the environmental justice vertical in collaboration with Center for Policy Research. She's been working on environment, climate change and energy-related issues since 2006. In the past, she's worked with Kapoor Environment Action Group and GIZ India, carrying out research projects and coordination tasks concerning environment, biodiversity, clean development mechanism and renewable energy. Since 2007, she's also been associated with EcoExist, a social enterprise taking care of distribution of eco-friendly products in Delhi. We extend a very heartfelt welcome to you. Matthew Idiculla is a research consultant at Center for Law and Policy Research, where he focuses on urban law and policy work. He is a lawyer by training and worked at the School of Policy and Government at Azim Premji University from 2007 to 2016. He has also been a researcher in the project Global Suburbanism, housed at York University, Toronto. Matthew's research interests are in the intersection of law, politics and policy, particularly in constitution and political history of India, comparative constitutional design, urban governance, local government law and critical urban studies. Matthew has widely researched and engaged with Bangalore's urban governance issues for many years now. Welcome, Matthew. Shweta Wagh is an academic and a researcher with a collective for spatial alternatives. Shweta holds a B.Arch degree from JJ School of Architecture and a Master's in Urban Conservation from Kamla Raheja Vidyanidhi Institute for Architecture and Environmental Studies, where she has also been teaching since 2009. Between 2000 and 2006, she undertook several postgraduate courses in ecological restoration, geomorphology, field botany, natural resource management and biodiversity conservation. Some of her work includes the Mathiran Eco-Sensitive Zone, the Geothermal Zone in the Tansa River Basin, Heritage and Environmental Conservation Guidelines for the Mathiran Development Plan, Conservation Framework for the Kanchenjunga Sacred Landscape in Sikkim, and Self-Development Guidelines for Urban Fishing Villages in Mumbai. Her academic interests include urban theory, sustainability, ecology, history, and conservation philosophy, about which she talks and writes extensively. Welcome, ma'am. Over to the panel now.
Good morning to all. It's great to be here. Great people on public holidays. I don't know if we had an event in Bangalore, this would have been the numbers. We are quite lazy and still we turned up. Anyway, there is a Bangalore lobby here, a lot of people from Bangalore. Anyway, it's great to be here. I'm Matthew Idiculla. I work on urban law and policy issues. This session is about mind the gap, rule of law and democracy, and trying to understand, the divergence between the law in the books and law in action. Much of it has, I think, been there in the discussion over the last 25 years, and I hope to sort of maybe ask some provocative questions. At the same time, give I believe the audience is mixed, so give a basic understanding of some of these issues. At the same time, maybe try to raise some questions. So the 74th Amendment is what has established urban local government in India. I mean, at least sort of uniformly established across India. We've had urban local governments even before. And it's interesting that we discuss this now. I hear that the elections to the municipal corporation here in Chennai has been delayed for a while now. And in fact, my entry point into this issue of urban governance happened in 2008, 2009. So it's been about 10 years I've been sort of engaging with this. That was because the elections to the Bangalore Municipal Corporation was delayed for a long time. That's how I ended up the question. So it's perhaps fitting that we reflect on some of these larger questions while we are here. So let me just start with what we have today. So today is the 150th birth anniversary of Mahatma Gandhi, and it is perhaps fitting that we are having a discussion on issues around the right to the city and questions of decentralization, but in a sort of interesting way, because I think most of you know that Gandhi by himself was opposed to the idea of urbanization, along with industrialization and the other components of it. But you actually notice in a sort of twist of history that if you look at the 74th Amendment, to some extent you can say that if the Gandhian sort of spirit of local self-governance wasn't there, you may not have had the 74th Amendment, which is for urban areas. And I put Ambedkar also there because, in my view, the 74th Amendment is actually a synthesis of both a Gandhian view of local government as well as an Ambedkarite sort of view of how constitutional government should be. Not that the local government framework was there when the constitution was enacted under Ambedkar, but the form it took in the end, it is quite distinct and quite different from kind of local self-government idea that Gandhi had sort of looked at. I don't want to get too much into the details of how it is a confluence, because let me just say that perhaps in a couple of sentences. So Gandhi was this big proponent of village Swaraj, village self-rule, and decentralization. But it did not. The Gandhian view, on this was actually quite muddled. There wasn't a framework or a constitutional design for it. Whereas if you look at the shape the 73rd and 74th Amendments finally taken, it has taken a very constitutional framework approach, and which provides clear reservation for scheduled castes and scheduled tribes, along with reservations for women, which are ideas which Ambedkar established. But if you look at the Gandhian, I'll just put this slide here. I don't know how many of you are familiar with this. If you have the time, please try to look up the Gandhian Constitution of Free India. This is by Sriman Narayan Agarwal, who is a Gandhian scholar. If you look at it, in the 1940s, this is before while the Constitutional Assembly was framing India's constitution, there was this alternative view of very decentralized form of governance that was proposed under this constitution. There is a foreword of Mahatma Gandhi to this book. The book is written by a disciple of Gandhi. Gandhi says, I quote, this is based on Agarwal's study of my writings. This is Gandhi's quote. and it is not inconsistent with what I would like to stand for, right? So it is by a double negative in Gandhi's style, it is an endorsement, of what of the constitutional design that is proposed. This never sort of saw the light of the day. If you look at the Constituent Assembly debates, this is largely dismissed. There were a bunch of people in the Constituent Assembly who wanted a Gandhian view of a decentralized form of governance, but it never really sort of took shape. And ultimately, what we've adopted, if you look at the constitutional provision, it's a very largely centralized sort of administrative system. We have a federal system, but with a very strong union. Okay, that is the sort of there are historical reasons for it. I don't want to get into the details because I'll be sort of moving away from the core idea of today's talk. So anyway, there is a longer history for local government in India. I think again, fittingly, one of the oldest municipal corporations in the world actually has been, as most of you know, has been, in Madras, right? The Madras Municipal Corporation, established in 1688, is one of the actually oldest municipal corporations outside of Great Britain, right? And over the years, actually, municipal corporations were the laboratories of democracy in the British era, right? Because you didn't have, state legislatures and parliament with enough popular representation. Whereas with Lord Ripon's resolution of 1882, you actually see municipal corporations having some power and some not universal at this point, but limited forms of elected sort of representation. So that is the history. And if you look at the 1950 Constitution, local government is almost completely missing, right? There are just two provisions in the Constitution that provide for local government. There is in part 2, Article 40, Organization of Village Panchayats, and then in the time schedule. So this Organization of Village Panchayats is in the Directive Principles of State Policy. As many of you know, it's not an enforceable provision. It can't be enforced in court. It's supposed to be the framework that constitution makers, lawmakers have to sort of keep in mind. This Article 40 came in as a compromise provision between the, I don't want to sort of oversimplify, but say a Gandhian view and an Ambedkar view. So this was put in, and the other key provision which still remains is that local government, including urban and rural, local government is a state subject, and much of the debate that we see now, around why is it that 74th Amendment has not been implemented, why is it that local governments are still being trampled upon? I think much of it is because it's local government is still listed under 7th Schedule List 2 state list, which basically means that the Constitution might lay down the broad framework of how local government should work, but ultimately the laws regarding local government, the rules regarding how local government should work, all of that, the overall administration is completely done by the state, right? So it is the state of Tamil Nadu which decides how the municipal corporation of Madras or Chennai should actually operate. Now, and this is how it was in the 1950 Constitution, and it continues to now. So, I'll just take you through the previous state bit quickly because I've already put 9 minutes. Anyway, the basic idea behind the 73rd and 74th Amendment was that there was something called the Community Development Program that was done in the 1950s. It seemed to be a big failure, and what this Balwant Mehta Committee and others have found out was that these programs, this narrowing vision of just going to the villages and developing it itself, by using this big state machinery, this modernist idea of development is just not seeping down because you do not have participation, you do not have local government institutions to make it work. You just have this steel frame, this bureaucratic Raj, which just goes and does it. And it is just not able to penetrate the social spaces and get things done. So this was the idea that was there. So this is 1950s. But over the years there has been a lot of debate. Ultimately till say Rajiv Gandhi came to power in 1984, there's not been much movement, at least from the center, on the 74th, on issues of local government. Ultimately, in 1989, something called the 64th and 65th Amendment were sort of framed and passed in the Lok Sabha, which provided for rural government and urban government. 64th was rural, 65th was urban. But it couldn't, Rajiv Gandhi did not have the numbers in the Rajya Sabha, so it didn't pass. Ultimately, it came about only in, say, 1992, after Gandhi's death and Narasimha Rao coming forward. Anyway, that's a quick history. But here's the interesting bit about the 73rd and 74th, and just a quick, context distinction between what these provide for. So quickly, 73rd Amendment, if you clearly look at it, provides for, it mandates the creation of panchayats at 3 levels, right? At 3 levels, that is village, the Gram Panchayats, intermediate level, which are block or taluk panchayats, and the district level, which are the Zilla Panchayats, Zilla Parishads, right? So that is 3 levels, 3 tiers of local government. Whereas the 74th do not provide for any multi-tier sort of framework. It just provides for 3 types of municipal bodies, right? Nagar Panchayat, that is for transitional areas, municipal council, that's for smaller towns, and municipal corporation for bigger cities. Now, and this is the framework which has largely been sort of used even earlier. So, just quickly recapping the statement of objects and reasons behind the 74th Amendment, and this is also more relevant now in case of Madras where elections are not being held. In fact, the very reason why something like the 74th Amendment was required was that failure to hold regular elections, prolonged supersessions, and inadequate delegation of powers and functions. Right? These are the core reasons why you made a constitutional amendment to provide for urban local governance in a democratic, participative, way. But you see, even now, some of these things not there in action. I don't want to get into the relevance of what it does. This is more of a constitutional law kind of question. I might lose the audience here. So basically, in a sort of simple way, if you do not have constitutional recognition of the local government, it becomes purely creatures of state, right? Local government is, this creatures of state is a US jurisprudential concept. Basically, state governments have complete autonomy on what it can do to local government. But because of 73rd, 74th, that's not the case now, right? It is not completely a creature of the state. So quickly, what does the 74th Amendment do? I'm sure many of you know about this. This constitution of municipalities, devolution of powers, reservation of seats, creation of state election commission, central election commission, mandating ward committees for every city with over 3 lakh population, creating DPCs in every district planning committees, and creating metropolitan planning committee for cities with over 10 lakh population. I really don't have the time to explain what each of them means. I'm sure many of you would already know about it, and we can perhaps get into it in the Q&A. So the most important provision of the 74th Amendment is Article 243W, which provides that subject to the legislature, subject to the other provisions of the Constitution, the legislature of the state may, by law, endow municipalities with so-and-so powers. And the powers are listed. The functions are listed under the third schedule. You can see what I have highlighted there. It's a may provision, right? This is the fundamental question that we have here. So if you look at the title of the talk, is 74th Constitutional Amendment, is it derelict by design or by default? So my argument is that it's both. There are parts of the 74th Amendment by its design, right? There are parts of the 74th Amendment by its design does not really mandate the devolution of functions because of certain may provision. And there are parts of the 74th Amendment which are strong, but for whatever reason it is still not sort of seeing the light of the day, right? So again, the 74th Amendment also inserts something called the 12th schedule. There are 18 functions listed in the 12th schedule, and these range from urban planning, regulation of land use, water, sanitation, environmental issues, all of them, and and the larger question is, it's not being actually devolved in many cases. So just about a couple of minutes, I might take one more, but anyway, let me just quickly run through some of the inherent. So inherent limitations, as I said, one is the main sort of provision. This is one of the issues of the scientific government. There are some main provisions which are there. Then, if you look at, say, distribution with 73rd, you will see that there is nothing called, say, a gram sabha equivalent in local areas. In rural, rural government, it provides for a gram sabha, which is actually a collection of all individuals, at least registered voters in the population. You don't have that either. So there are some of these inherent limitations. But the other sort of key, the larger problem is in the way, not just in the inherent limitations, but in the way it actually sort of functions. So one is governance through parasites, which is many of the functions which are supposed to be done by the municipal corporation, including urban planning, regulation of land use, in some cases slum improvement, environment, in some cases like kind of water supply. Many of these are not done by the municipal corporation, are still done by what are known as parasitical agencies created by the state government, which are not accountable to the local government. So hence local governments, actually do not function in an effective way. This is just about jurisdiction problems. I'll not get into it. The other is the powerless mayor question. So Chennai has a mayor with 5-year term and all of that, and it's alternated between direct election versus indirect election. There's a lot of talk on direct election, indirect election of mayor, but the larger question, which sometimes we miss, is whether the mayor has executive powers. If you look at Indian city, if you look at Indian legal system, they clearly provide the commissioner, who is an appointed IAS officer. The commissioner has been vested with all the powers, so the mayor actually does not have enough powers. So the executive power is not with him or her, right? So this is the larger sort of question, and then absence of fiscal devolution. If you look at the 73rd and 74th Amendment, it does not actually provide for a separate domain of taxation, right? Local governments do not have a separate domain of taxation, where certain, you still have the taxes determined by state legislations, right? So hence, it is completely up to the state to decide what power, how much money goes to the local government or not. I don't want to get into details, perhaps some of the other panelists might speak about this. There is a larger question of centralization of urban governments. You see since, say, in 2007 and now Smart City Vision, you see a centralization of urban governance, with not just the state government saying how the local government should function, but even the central government imposing certain ideas of, with tight conditionalities, certain ideas of what city government should do, right? So last time, this is the larger question of SPV-driven urban governance. I believe there might be one more panelist who might speak about this question, so I'll just avoid it and come to the concluding questions and thoughts, right? So here are some of the large questions that we should think about now that we have done 25 years of scientific government. One is, and we could take this up with early and so. So one is the question of whether the 74th Amendment was decentralization from above. There was no major push for decentralization from below. So is that top-down sort of process itself, and is that why some of these things haven't worked? The other larger questions around, does it alter the federal nature of Indian state? Has the 74th Amendment created a 3-tier system where you have union, state, legislature and local? Or are municipal corporations and municipalities an independent tier of local government, or are they just units of the state government? And even larger questions, why do we still use the term ULB, urban local body, when it's not mentioned anywhere in the constitution, right? It is a government, it's not a body, whatever it is, right? It is an elected government. And larger questions around, should we revisit the 74th Amendment after 25 years? And if we are revisiting those, these questions, what should be the fundamental values that should, drive urban government redesign? What should be those fundamental values? These are larger questions we should think about, and maybe, over the course of the day we might take it up. Thanks.
About amendments to forest and environment law and how that has been problematic inherently.
Good morning, everybody. I'm Meenakshi. I work with Center for Policy Research.
on a program called Environment Justice, wherein we work with the communities and try and use the different legal protections that are available in our given regulatory system to mitigate the impacts that people are facing, people who live around development projects or who are impacted by development projects in one way or the other. So for us, like our sites for now are largely rural, and there urbanization is seen more as the problem when villages are the sites of the waste from the neighboring cities, or they are the dumping sites usually. So urbanization there usually seen as the problem, but here I'm like the topic here today is that how, like what is the status of the entitlements that an urban citizen has? How is the government providing that, and what are the spaces available for that in our regulatory system? So I'll focus my presentation on that only. So we'll be talking about the spaces and how these spaces are over the course of like so many years shrunk by the government through different amendments and dilutions. Okay, so I'll start with the coastal dilutions first. There are a couple of reasons why I'm starting with this. First is because I have tracked this for the past 4-5 years now, so I'm most familiar with this law. And also, if you look around, like in most of our cities, be it Bombay or Chennai, are coastal cities, and coasts are facing the pressure of urbanization, and there are certain expectations that people have from coastal land use and the governance of the coastal areas. So that's why I'm starting with that. So maybe this entire chronology, I will not spend too much time on it. I'll try and just quickly run through it. This is how this notification, there is a law that governs the coastal areas. It's called Coastal Regulation Zone Notification 2011. After 2011, for 3 years till like 2014, there was nothing, no development or no changes that happened in the law. But since June 2014, the notification, the law has gone through a number of changes. Like there has been a slew of some around like 10-11 amendments that have happened to the coastal law. So first, in June 2014, the Ministry of Environment and Forest and Climate Change, it set up a review committee called Shailesh Naik Committee under the chairmanship of Shailesh Naik, who was heading the Ministry of Earth Sciences then. And they reviewed the coastal zone notification, and many people would think that, yeah, what is wrong with a review? If it happens after maybe 4-5 years, you would want to see how a law is performing and how is it being implemented, and if there are needs for certain mid-course corrections. But this review was limited to only the state governments. So the committee, while reviewing the notification, it only consulted the state governments, because states had certain demands and they wanted to promote tourism and a couple of other development aspirations they had, and for which they had approached the Ministry of Environment and Forest, and on their request this review was initiated. So the committee, after 6 months, it submitted its report, and the report was not made public for a really long time. And even after like repeated RTI applications, appeals, the report was denied to us for the reasons that the report is still under consideration and we cannot share the report till the time we have taken a decision on it, which was not really a valid reason for denying documents to a person if it concerns to that person or to the larger public. And then, while this report was still not out, from January 2015, from January 2015, the report was submitted, and since then, and even before that, the amendments started flowing in. So there have been around like 10 amendments related to the coastal regulation zone notification, and all these amendments, what they did was, some amendments allowed for, like provided for more tourism projects or infrastructure projects and development of ports. So all these activities were facilitated through these amendments. Then in January 2015, in the year of 2015, the ministry decides that we need to replace this law, which has only been like 5 years, not even 5 years old, replace it with a new legislation. And I should give a little bit of background to the 2011 notification. This was a long drawn process after which this notification had come out. There were lots of public consultations that had happened in all the coastal cities and coastal areas. Mr. Jairam Ramesh himself was involved and visiting all these areas and meeting the experts there and fisher communities, which the fisher people had raised a lot of objections and they had a lot of things to say while the 2011 notification was being drafted. So this 2011 notification had come after a really long and elaborate process of public consultations. And now you can see that not even like 5 years of its implementation, and we are thinking of replacing it, and without consulting the same people who were part of the public consultations initially. So all these things happened. And then recently, last year, there was a news that the ministry has finalized a new draft for the notification, which is called Marine Coastal Regulation Zone Notification 20. Then it was 2017, but there was again a lot of, because the news had leaked out and we filed a couple of RTI applications, we got the drafts out, and then fisher groups wrote to the ministry, so maybe because of that it was recently. In April, the ministry has issued the new draft. So this draft was open for 2 months for public comments, and now it has already, in my recent RTI file inspection visit to the ministry, it has already received over 400 submissions, which are largely objecting to the replacement of the old notification with this one. And while all this was happening, this bigger process of review was happening, amendments were coming in. Piecemeal amendments to allow one, like with each amendment, the courts will open up for more development. So here I have put the dilutions in numbers. So far there have been 11 amendments to the Coastal Regulation Zone notification. And out of these, because our topic is public participation, that's why I'm focusing more on this, that how these cases are being shrunk. So out of these, 6 have not, there were no drafts to these notifications. So these were just final notifications that were issued by the government directly. So no drafts means these are not open for public comments. So the right of the citizens, of the coastal citizens, to comment or to maybe give their suggestions on a piece of legislation that concerns them had clearly been taken away from them here. Then there were 2 clarifications regarding what is a coast, what is a facility that should be permitted on the coast, and things like that. Then there was a review that I've already talked about, and this review, as I said, though the review itself was 6 months long, but it took us 1.5 years to get the report out. So we had to file RTI, then first appeal, then second appeal, then the CIC, the Central Information Commission, had to pass an order saying that the report should be made public, and then it was given to us, the copy was given to us, which was then shared with the larger public. And now currently the revision for the replacement of the notification is in process. So all this has happened in the last 4 years. So these amendments, as I mentioned, with each amendment the courts were opened up for more development. So these were concerning these. All the red text means that these were the changes that were made without any public comments on these. So whether it was to allow more tourism projects in urban areas, in coastal parts, so for the coast, usually what happens is when the zonation of the coast is being done, the areas are demarcated as urban coastal areas, rural coastal areas, water areas, and there is a hazard line that also demarcated. And earlier, like in the past notification, the area between the coast, the 500-meter line, which is largely the CRZ, the Coastal Regulation Zone limit ends, so it's 500 meters. So from the 500-meter line, if the hazard line falls beyond the 500-meter line, even that area was protected as CRZ, as Coastal Regulation Zone. So now the ministry, through an amendment, has done away with that, which means that the areas that are vulnerable to any kind of like natural hazards, they don't have any protections anymore. So they're just saying that you can think about it through your special hazard management plans, but those are not part of the Coastal Regulation Zone protections anymore. Then there have been many amendments to the Coastal Zone Management Plan process. So under the 2011 law, there was this entire exercise of planning development for the coast, how these zones will be marked out, which I said urban areas, rural areas, how those will be marked out, and what kind of activities will be regulated there. All these things were to come in the coastal zone management plans. So under the 2011 notification, in 2 years time frame, all the states were supposed to put out their coastal zone management plans, and which is still pending. So it's been now 7 years, and coastal zone management plans are pending, and there have been like multiple extensions to the deadline for finishing the coastal zone management plan. The latest was September 2017, and now we are hearing that because the new notification is also out, so the ministry is really pushing the states to complete this exercise. Other than the coastal amendments which I've gone through in detail, I've also listed here some environmental amendments which I think are important even for urban citizens in terms of they sort of like they snub the spaces or the possibility of public participation. One is the amnesty that has been in like last year, 2017, March 2017, the Ministry of Environment and Forests had said that all the projects which have started work without an environmental approval can now seek environmental approval, which basically means that you are condoning their mistakes or their like whatever wrongs they were doing, you're condoning those, and you're providing them an amnesty. So this was done first for the environmental approvals, and this year in March 2018, it was done for the CRZ approvals as well. That all the projects that have started without CRZ clearance can now seek one time. There is a window for 3 months in which they can seek clearance now, which effectively means that because this is not a really long drawn process of environmental clearance which usually takes place, the review will be it will be rushed through, and also there won't be any opportunity for public hearings, which is usually the part of environmental clearance process. So those are taken away from the citizens for the projects which have already done like certain wrongs. So you cannot really trust them again, and that the power of citizens to be part of public hearing and hear about the project and give their comments have been taken away. Then the validity of mining projects which were issued earlier before the new assessment procedure came into place in 2011. Earlier the validity of mining project used to be 5 years, but in 2011 it was made 30 years. So all the projects that were given clearance under the old law before 2011, their duration was 5 years. Every 5 years they would be renewed, or they would be reviewed and then renewed. So here their term was extended to 30 years. Again, your chance, public's chance to comment or be part of public hearing every here when usually these reviews happen. So then again the process of review has been compromised here. Even environment clearance and CRZ clearances validity has been increased from 5 to 7 years through an amendment. Now recently what ministry has done is last year it came out with a set of fixed TORs, terms of reference for projects that are seeking environment clearance from the ministry. They're saying that instead of while the expert appraisal committees look at the projects, they can try and give them these fixed set of terms of reference. Yeah, there are possibilities for these committees to give extra terms of reference or extra conditions, but we know how systems work in our government, and if there is already a set procedure or a set of conditions, people would your natural thing is that you would go by that, and maybe one or two couple of things would come along with it. So this again meant the entire process of reviewing or looking at a project proposal in an independent manner was compromised when a fixed set of conditions are now being suggested for environment clearances, and most recently for forest clearances as well. I tend to be a little fast. If I am going fast, please let me know. Then there have been amendments, while those were the amendments that relate to the public participation, which These are the amendments that I thought would be interesting because it clearly affects the urban citizens. For instance, for effluent discharge for sewage treatment plants, the effluent discharge standards have been revised, and these again have been done without any public comments. There was no draft. There was straight away an amendment. Usage of water by thermal power plants, that has increased. The limit for usage of water, the amount of water that they can use, that has also been increased. And thermal power plants, I don't know if people here know that the emission standards, air emission standards for them had been revised some time ago, and they were given a period of some period to abide by the new standards. But the ministry, on behalf of the thermal power plant sector, has reached out to the court seeking more time, another 5-year extension for them to abide by the new air emission standards. And this is when we are all talking about air pollution. I'm coming from Delhi, so every winters the issue of air pollution comes up. And then for the construction projects which are below 20,000 square meters, construction projects, which is a big issue in all urban areas, they can self-regulate themselves. They don't require an environment clearance. They can self-regulate. We know what self-regulation means. And now there is a proposal to increase this limit to 50,000 square meters. This is my last slide. So these are the dilution in the land laws. So as all of us know that in the 2013 this right to fair compensation and transparency in land acquisition and rehabilitation and recompensation, and this act came out in 2013, and after that the central ministry was trying to bring in do away with the clauses related to social impact assessment and consent of people, the owners of the land, through the ordinance. While this could not go through because of a large opposition against the ordinance, now the state governments are coming up with their own laws that are basically doing the same thing that ordinance proposed to do. That is to do away with the social impact assessments and consent-related clauses. For instance, certain states have come up with their own acts, and certain states have issued rules under the Central Act. So for instance, Gujarat and Telangana, they have given exemption to many projects for consent and SIA. Then Maharashtra is asking for SIA's social impact assessment only from the private projects, not from public-private partnerships. And Tamil Nadu allows for acquisition under state laws. These laws are related to Harijan welfare and infrastructure development. So if any acquisition happens under those laws, then the RFCT LARR provisions will not apply as per the Tamil Nadu State Act. Then there have been certain rules as well. For instance, in UP, the government has removed requirements of prior consent, public hearing, and in Jharkhand, the Gram Sabha, village assembly quorum, which is usually half of the Gram Sabha should be present to take a consent vote, has been reduced to 1/3. And compensation has been reduced in many states, in Haryana and Tripura being two of them. Recently, Chhattisgarh Assembly has amended its law and has allowed for direct purchase of land from the tribal landowners if there is consensus. Features that come out of all these changes that have happened in the past 4-5 years, overlapping time frames. For instance, this year when the Coastal Regulation Zone 2018 came out, the draft, at the same time National Clean Air Action Plan came out, and at the same time draft Forest Policy came out. So you had 1 month for Forest Policy, 1 month for Clean Air Action Plan, and 2 months for CRZ notification to comment upon. And this would compromise the submissions because all these three legislations concern most of the residents of India. Then all these drafts, they have the language that they use, they seem like it's nearly final, and already so much time and energy has gone into it, and there is no point in commenting on it. They seem like almost ready to just turn into the final document. And drafts come with ministerial backings. Already meetings happen with ministries such as Tourism Department and the Ministry of Shipping, and then it seems like you've already, again same thing, invested so much in it in terms of time and consultations as well, that this seems like a perfunctory exercise of seeking comments. Then reviews are kept closed door. As I shared about Shailesh Naik committee, the report was just not shared. And processing is very discreet. If you ask them what is happening, you don't get a clear answer. Like they just send you from one office to another, and you're just doing circles of the ministry. Seeking information under RTI has become really difficult. You don't get anything like really straightforward anymore. And piecemeal and frequent amendments mean that all these laws have become a patchwork. It's very difficult to read them and make sense of them, and implementing them, or even like implementing them, is a different ballgame altogether. And then finding what is missing, what needs to be done, what is not happening, it's not at all easy, because there's so many amendments and different changes that have happened in different periods of time. That's it from my end.
Thank you, Meenakshi, for throwing light on inherent problems in the way our laws are made, shrinking spaces for public participation, and reducing democracy to merely electoral politics. We will now have Shweta Wagh. Shweta will talk about legalizing exclusion through the process of mapping.
Hi, so I'm Shweta. I'll be talking about legalizing exclusion through planning, definitions, categories, and regulations. In this presentation, I will attempt to interrogate the role of planning, which precludes many from their right to the city. Planning may have social goals, but here I'm going to speak of planning as an epistemic process. Through acts of naming, classification, and definition, planning constructs its objects, determines or shapes social action. I'm going to speak of planning as three interconnected domains: the territorial domain, the systemic domain, and the regulatory domain. The territorial being the conception of physical space, the systemic being the conception of infrastructural interactions, the regulatory being the conception of transformative protocols. In concrete terms, planning is physically operationalized through the zoning of territory or space, through the creation of infrastructural networks, and through the framing of development control regulations. In this presentation, I will see how these three domains intersect in the direction of space, encompassing and demand, by social exclusions. One of the key instruments of planning in Mumbai is the development plan. The first sanctioned in 1967, the second sanctioned in 1991, and the third sanctioned last month. However, when I speak of planning, I am not restricting myself merely to the master plan, but the whole process of spatial and environmental decision making. Let's take the case of one of the most spoken of controversies vis-a-vis the Bombay DP, that is the opening up of RA Colony, earlier categorized as no development zone for development, which was widely contested by middle class as well as environmental groups across the city. In the second iteration of the city's DP in 1991, there was a fixed category in the demarcates the no development zone. The no development zone subsumed around 13,000 hectares of forest areas, forest. All these were classified under one category where building activity had been restricted. When introduced in 1991, the lines that carved out the no development zone drew a clear distinction between urban territory and what was planned and the non-urban territory which was left alone. The restriction of development activity tacitly allowed thousands of people to continue with their livelihoods based on primary occupations, despite these activities seeming incongruous in the image of the modern metropolis. In the case of RA, is also home to small hamlets or villages belonging to the Adivasis. These are known as the Adivasi Padas. There are also buffalo sheds and grazing areas which belong to the dairy industry. In the 1900s, the regional plan proposed that polluting activities be pushed out of the city to make way for recreational functions. But this push for a sanitized city transformed Mumbai. Urban peripheries were converted into dumping grounds for waste and slaughterhouses as well as favelas. Buffalo sheds began to be relocated outside the city, in the Vasai Virar region in the city's northern peripheries. And what we see to the right is NDZ and how they began to house low-intensity recreational facilities. This is Royal Palms Golf Club and some residential luxury apartments related to it. So there were resorts, golf courses, clubs, and even lavish residences allowed permissible within those NDZs. So the earlier draft version of Mumbai's development plan in 2014, which was called the EDDP, did away with the idea of the NDZ. So if you see, this is the NDZ in, sorry, this is the NDZ in the 1991 development plan. This is the boundary of RA, which shows the buffalo sheds. And we see that in the earlier draft development plan, the NDZs have been opened up for commercial and residential development, and many of them have also been zoned as open spaces. But what this plan did was it introduced a new category called natural area. So here we see this dark green. This is the zone called natural area which was introduced. So what this did was, how the natural area was demarcated was not based on any ecological assessment or a mapping of ecosystems or natural areas, but rather on legal territorial criteria. So it was urban water bodies, forest lands controlled by the forest department, mangroves and intertidal zones which were protected by the CRZ or the coastal regulation zone were mapped as natural areas in the earlier draft development plan. And consequently, as a result, about 20% or about 2,600 hectares of what was earlier NDZ but not natural area as per this classification was proposed to be released for urban development. So this excluded many natural and semi-natural landscapes which were earlier a part of the NDZ. Here we see RA colony earlier and NDZ. In the EDDP, it has been identified as an emerging growth node with potential to accommodate new commerce, cultural and institutional activities combined with the provision of large open space infrastructure. This is a large open space proposed on the lines of Central Park in New York or Hyde Park in London. What is also proposed is the Adivasis were proposed to be relocated in high-rise apartment buildings in one corner of the land, similar to the SRA model. Environmental groups strongly reacted strongly to this perceived loss of the RA fringe and forest cover, and they demanded that the entire zone be zoned as a natural area with limited public access. The other conception was to open up RA for urban growth, and the other was to preserve it as a natural area. However, both these conceptions or imaginations did not consider the habitations and livelihoods of communities that depended on RA. Those were the Adivasis, the squatter settlements, the dairy workers, who were alienated from these imaginations. The Adivasis also rejected some of these proposals to rehabilitate them, and in some of the development plan consultations, they actually demanded that their 27 padas be demarcated on DP maps. What we see is that due to the widespread opposition and the scrapping of the NDZ, in the earlier draft development plan, the earlier draft development was also scrapped due to public outcry. There was a revised draft development plan known as the RDDP which came in, and this retained the no development zone category. So what we see here is the green. So now the no development zone has been shown as green again. But in this case, deceptively, it has been redefined as potentially developable land. So now, although the NDZ category is retained, it is defined as land kept in abeyance for future development, being brought under a policy where such lands would have come forward for development. So basically, the RDDP's NDZ policy proposes to bridge the city's major deficit, offers incentive to developers. What we see here is the revised draft development plan, and the NDZ has now been zoned as a special development zone in the proposed plan. We also see a grid of these orange roads which has cut across the NDZ, and this indiscriminate grid of roads runs over a landscape of urban villages, self-built settlements, water courses, fields, roads, drying yards, and also the coastal commons. This is Mayoni Fishing Village and the area surrounding it. And the NDZ has been proposed to be, they have proposed large plot amalgamations with high FSI, where affordable housing will be constructed by developers through the without any consideration of the existing uses or the natural and social ecology of the area. In addition to the rebranding of the revised draft development plan also permits the use of 130 hectares of salt marshes, which were also, so these were the salt pan lands for affordable housing.
This area to construct a central park requiring amendments to the CRZ of the Coastal Regulation Zone. Now this regulation, which is a violation of coastal protection law, is essentially justified by framing it as, there's a term in the development plan called green reclamation. Green reclamation is the idea of reclaiming land from the sea for the creation of open space, which makes it justifiable as an environmentally friendly measure for creating more open space. What we also see is the territorial bias in Mumbai's planning system and how it has struggled to come to grips with the complex relationship between land and water. The territorial approach conceives of land as space or territory rather than as dynamic relationships between interconnected systems. Development plans earlier development plans also proposed planned expansions, public housing, social infrastructures and reservations over wetlands and marshlands. And much of this public housing, however, never got built, but informal settlements often occupied these lands and built low-cost housing on these wetland areas. It continued unfazed by the new and newly framed environmental laws. So all this area was earlier mangroves. This development has come about in 2000. That was much after the CRZ was notified in 1991. So Mindspace and BKC were allowed to happen. However, it was only after the floods It was only after the floods in 2005 that inundated most of the city did Mumbai's hydrology and drainage problems emerge as an issue of serious concern. In the aftermath of the floods, the city's water system suddenly assumed significance. Environmentalists argued that Mithi is a river and not a nala, as was generally perceived. Environmental systems began to be seen as these dynamic entities and that transcended administrative or property boundaries. Environmentalists also decried concretization and containments of rivers into channels or narrow nalas. A powerful critique of the city's indiscriminate and haphazard development practices began to emerge. This is the reclamation, this is the runway which has been constructed, which has constricted, this is the airport in Bombay, which has constricted and diverted the Mithi river. So, despite these concerns, rather than a comprehensive planning approach based on ecological principles, there were two kinds of project responses. The first was based on technological and engineering inputs with mechanisms to divert, channelize and flush out water from the city. A major stormwater drainage project called the Brinstow Ward was initiated in 1993. The project required the creation of stormwater drains, a network of stormwater drains, concrete embankments along nalas and pumping stations, with the intention of draining out water through a built system of pumps, pipes and passages. So this is the pumping station being under construction at Khardanda. This is Khardanda Fishing Village. This is where this is a reservation in the RDDP for the pumping station, which is right on top of the estuary. These areas were earlier mangroves. A lot of them were destroyed during the construction of the pumping station. So essentially what the pumping station does is it destroys the mangroves which are upstream of the project. So we see that this area, the tidal water has been blocked here. It flushes out the water, but it doesn't let water in. So the mangroves which are upstream of the project usually die. And it also therefore destroys the ecology of the estuary. while it alters the high tide line, enabling development. So these are slums that have come up upstream of the pumping station. All these were earlier mangroves and wetlands and were CRZ1 areas, but automatically through the shifting of the high tide line, these areas have now been opened up to enable development. The second kind of project response was based on an appeal to the middle class aesthetic concerns of a disciplined slum-free urban space. The narrative of infrastructure failure implicated the poor as a major contribution to the city's environmental crisis. So it's usually the poor who are blamed for flooding. And in response to this, we have water beautification projects initiated and taken up as these localized interventions aimed at cleanups both of the garbage-laden river as well as the slum-laden banks, promising a rejuvenation of its ecology by ridding the floodplains of polluting activities and illegal encroachments. Simultaneously, we also have the state's environmental policy. So in the DP, we have a new orientation towards commodification. There are green interventions proposed in the DP along these rivers and water bodies. The RDDP's arbitrary sanction of 5 meters around water bodies, a sanitary cordon, are termed as the green buffer. So, similarly, beaches are classified as open spaces in the development plan, reinforcing their imagined role as a space for recreation and leisure as opposed to being perceived either as a natural area or as a coastal common. In Mumbai, the coast has traditionally been the home occupied by the Koli or used by the Koli community for a range of activities ancillary to the occupation of fishing, ranging from the cleaning and drying of fish, the mending of nets, the docking of boats, and these constitute the coastal commons. The CRZ notification actually requires the demarcation of the coastal commons and areas used for fishing related livelihoods. Residents of Koliwadas across the city argued for the demarcation of fish drying areas as fish drying areas in the DP. Earlier, many of the beaches and also many of the areas used as coastal commons had been zoned as open spaces in the development plan. Therefore, now many of these have been recategorized in land use maps as areas reserved for primary activities, specifically fishing and ancillary activities. Despite this, there have been consistent efforts by the urban middle class and residential associations to appropriate and commodify the commons by displacing traditional livelihoods. The ugliness of these productive activities and the stench of dry and rotting fish needs to move away, and there is a characterization of these areas as nuisances or polluting activities. These are under threat today from beach beautification, recreational tourism, as well as coastal infrastructure projects. One of the justifications for the coastal road project was that it would provide, improve the health and quality of life in the city through the creation of new open space for the land-starved city. And this would be done using a mechanism called green reclamation. Despite favoring private modes of transport, as it will create. It was said that the coastal road would create more public amenities, and therefore it was sort of considered as a project of public interest. While the CRZ has consistently been used to criminalize the poor encroaching on mangroves, also which are classified as CRZ1, it has been amended to permit the construction of stilt roads and reclamation in mangroves in order to clear the coastal road project. A recent High Court ruling also argues that mangroves are a fundamental right and it criminalizes their destruction, but it makes an exception in case of projects of public interest, and yet what public interest is here has not been clearly defined. It is therefore seen that existing legal categories are often used to criminalize the poor, but seldom have been a hindrance to large infrastructure projects, especially those sanctioned by the state. The real agenda behind mega infrastructure projects like the Coastal Road is to encourage real estate development through speculation along Mumbai's water western coastline. These speculative trends are already affecting fishing villages and livelihoods in northern unurbanized fringes of the city. Dilution of the CRZ in the 2011 notification in Mumbai has given special consideration to allow redevelopment projects to provide for the housing needs and improve sanitation for the city. SRA projects and cessed buildings have been exempted from the CRZ. So you can have slum rehabilitation schemes and the redevelopment of dilapidated buildings even in CRZ areas. Now there are even more further relaxations with the new CRZ notification. Although the 2011 notification mandates the demarcation of Kolivadas and their integration in CZMPs or the Coastal Zone Management Plans, this demarcation has not yet been carried out. In the meanwhile, there is speculation both from within and outside the Kolivadas. Due to ambiguities of classification, one kind of settlement and also accompanied with an incentivized development regime, one kind of settlement is often classified as something else, as opposed to, for instance, in some cases, Kolivadas are classified as slums, and the reason for this is that they can avail of differential development rights or additional development rights going into an SRA, as opposed to being classified or demarcated as a Kolivada, where you have height restrictions and you have to follow the Gauthan town and country planning regulations. Here we see that, for instance, Varli Kolivada was classified as a slum. A part of Versova Kolivada has also been classified as a slum to undertake a redevelopment by the Machibar Trust or the Koli Trust. There is also a push towards, another trend that we see is this push towards individual property rights as opposed to common property rights. And this is especially certain parts of the fishing community who are non-fishers who are pushing for this. They are actually, because common property rights would require the demarcation of CRZ3, individual property rights would give people land titles. So we see this kind of individual or small scale speculation that has started through small developers in Versova. This will result in the commodification of the commons. What we also see are these more ambitious plans where some factions within the community are attempting to get a DCR amendment for Kolivadas, which would enable cluster redevelopment. These approaches are being contested by others within the community who are still dependent on fishing. So in this case, we see that many of the lands which were the Varas lands or earlier classified as the coastal commons have been used for the sale component, and this is the rehabilitation for the slum dwellers, and this is the rehabilitation for the coolies. So these are some proposals that we see within the Koli community, but again, it is some factions of the Koli community who are no longer associated with fishing as a livelihood. I would like to conclude by saying that much of the contestations over Mumbai's development plan therefore was over how things were named, classified, defined and delineated. Acts of naming and classification are political acts and not purely descriptive ones, and therefore need to justify themselves. The change of public housing to affordable housing and resettlement, the definition of no development zones being changed to potential development zones, the various semantic shifts in settlement classification, all of these are indications of the fact that planning is as much a struggle over meanings as it is over land, habitation and livelihoods.
Thank you, Shweta, for marshalling the implications of development-led planning processes on resource commons, on indigenous communities and traditional livelihoods. I suppose the question we must be asking is not what is development, but who is it for, right? Okay, so we will now move to the Q&A session. I think we have about 5 minutes. 10 minutes. When you ask a question, please quickly just introduce yourself and keep it as short as possible. And may it be a question and not a comment.
Yes, sir. My name is Ganesh. I'm an assistant professor in Hindustan College in journalism and communication. My question is, when we talk about urbanization modernization development, we always talk about the Western or the known models. Are there any other models which are not known, like a Gandhi Swaraj model or something we can take up in the local level, and how we can go ahead and develop in that particular aspect? So, is it possible, or can we look into that kind of a thing? Thank you.
I suppose, sir, your question is directed to Mr. Matthew.
Matthew, yeah.
Yeah, thanks. Well, there are interesting sort of alternatives that have been proposed that are in practice. So, I mean, I'm not so much of a practitioner to give examples of that. I would just ask you to look at, say, there is something called Vikalp Sangam. I don't know if you're familiar with it. This is done by Kalpavriksha and other groups which bring together what are known as alternatives. Right? There's a whole series of alternatives to development that have been proposed, which looks at self-governance models, which looks at not exactly Gandhian sort of idealistic stuff, which is almost in the air sort of idea. This is more in practice, and these have been, every year there is a Vikalp Sangam where all these different alternatives are discussed, and so it might be good to sort of look at that. And I mean, I would also, since you're a professor, I would perhaps ask you to also look at something called the Aund experiment. There's an interesting book on the Aund experiment that was done, say, in pre-independent India. This is in a princely state where ideas of self-governance was tried out, and actually Gandhi completely endorsed this idea of this Aund experiment. So there are, these are just a couple of examples I'm giving. I'm sure there are more, but I'm sure if you look at Vikalp or the idea of alternatives to development, you would find many, and the question is, to what extent can you sort of make it under a legislative framework or a legal constitutional framework, and to what extent does the 73rd and 74th allow it or constrain it? These are the larger sort of questions that would be raised at that point of time.
So I have a question to both the first and the second speaker. So on the one hand, India has always been characterized by a divide between political and social life, where participation in political process by the general public is low. And on the other hand, a lot of these participation skipping processes, such as the example that you gave of giving a very short window for projects to get reapproval and that easy amnesty. So that is usually sold as a way of cutting the bureaucratic red tape and saying, there's a lot of bureaucracy in this country and we can fast track it for you. So how can you reconcile the existence of bureaucracy, where you have to get the participation of a huge public, and also getting things done at a reasonable time? So how can we reconcile this at a policy level?
Okay, first thing, I don't think you're really cutting the bureaucracy here if you're saying that we're giving amnesty. You still have to go through the government procedure. It's just that it's quicker. So it doesn't really mean that there can't be a cut for the government officers or anybody to ensure that you get the clearance. So bureaucracy still remains in the picture, and the license Raj would still be very much in the picture. Only thing you are compromising on is the public participation. But as you said, that how to reconcile the two, ensuring that development happens at a faster pace, and I think that in fact public participation is can work as a check to ensure that bureaucracy doesn't really impact the projects as much, because then you have another third party which is looking at this entire regulatory process and the environmental clearances or all kinds of clearances that are happening, but somehow the government has that opinion that communities or people, they can't be the third party because they have certain interest, or usually anybody else can be the third party. All the EIA consultants who usually copy paste things. Recently we had this example in Delhi where this 16,000 trees were being cut in the South Delhi area, and the EIA reports for those which don't require any public hearing because it's a construction project, as I mentioned in my presentation, that construction projects below a certain area that don't require public hearings. There the EIA reports had information from Chennai in Delhi document. So these are the kinds of work that is happening, and then I think that public participation would ensure that regulatory process, there could be another guard looking at it, which I feel could work. So I don't really see them in contradiction or in conflict really.
Just adding on to it, I think, yeah, so the question is, even if you had the, under the bureaucratic Raj, say, before 91, it's not like you had public processes, in place. So the question is, you could have public processes in place where public participation is possible, but that is not the, necessarily the sticking point, which does not allow quote unquote development to happen. There can be other means by. So I don't see it necessarily to be opposed to each other, because you have bureaucratic systems which are in some way a barrier which might operate even without processes. But if you have clear defined public processes, I think it can sort of work together.
Yeah.
Hello, I'm Nanda. So I happened to join this meeting accidentally, but it's good. I'm able to see a lot of youngsters who are interested on the country's development. That's a good part. And actually, one question came to my mind about what is it being expected out of this meeting. So you three people have presented a lot of information. As a common man, what is it expected from me? Maybe I know it is one kind of awareness. Okay, at least be aware what is going in the country, and maybe there may be a situation I may take part in some of the activity. That could be one of it. But is there any other expectation out of it? I have other questions. Maybe I would like to get an answer for it. Sorry if it is a wrong question.
There is nothing like a wrong question. As far as I am concerned, I think the expectation that I would have from the audience here is, as I mentioned, the spaces for public participation, engagement are being curtailed. Just be on the watch, raise noise about it, talk about it, let just not this thing die. That's what my expectation is from the group here.
Thank you. I think it answers me. The other question I have is, I understood that the public hearing is getting reduced, and the feedback times are reduced. But I'm looking from a different perspective. With the technology around us, the kind of forums we have and the social media we have, we can very much fast our responses much quicker. We don't need a 6 months of hearing review time. I mean, it's enough for us to put a tag in a Twitter to get the whole attention of the world in a day. So 2 months is a good enough time to respond to a review. So, I mean, I know that time is reduced, I agree, but participation is something which I am looking on as something where I am finding a lack possibly. Maybe the public people whoever I am seeing, sorry, I am getting into the comment mode, I am excusing you, please excuse. So, is there, I think the other part I understood is, the question I have is, if the government is intentionally doing certain exceptions and then they going forward in clearing certain projects, but there is a possible mechanism through which this information will be available for us. So isn't not available, or are we not getting the source of those information? I mean, I would say as a common man, my legislators are the first person who may know this information. Are they not ready to share this information to the public? If they are ready to share with the public, then there is no issue of people not being participating in it. So isn't the legal system taking the course to make any correction in it? So my question lands at is whether the members are not playing the role, or the elected members I mean, or the legislative system is not helping on it.
I think your question really is it the process or the people, right?
Yeah, both.
Okay.
I think it's both, right?
Do you have any specific, you want to direct your questions?
Yeah, direct question is, isn't this information or not known to the elected members, who should be first bringing to the notice to the public, and so the public participation can happen by itself. So is it not happening is my question.
I can answer for the environmental sector. For that, the reason that I've been going to the ministry trying to file RTI is precisely this, that the information is not available publicly, even online. And I am not really endorsing the idea. I don't think what the reach of, like, how digital are we currently. So I am not really saying being all the information being available online is the answer, but even that is not being done. And also I didn't say that the time period for public comments is being reduced. I said that in the same period 2, 3, 4 notifications are coming together, which means you have to look into 2, 3, 4 thick documents, which is like 500, 600 pages in that short period of time. The problem is this, that we are being like, it's like a flood of information that is being thrown on us, so that we miss out on 3, 4 at least out of the 6 that they are coming out with. So these are the things that I got from this question. I can't really comment on whether the government is ready to share the information or not. That is a conclusion that for all of us to like have our own inferences on. I've shared the fact how things look like right now. If you think that the government seems like it's not open, it's your inference, I would say.
In relation to the Bombay development plan, again, the development plans were published, like the draft development plans, but it was actually citizens who came together, and we had different NGOs, citizens groups, institutions who came together and deliberated and discussed these to come up with a more systematic critique. And there were different groups in the city who had definite interests, who articulated different parts of that critique. So I think it's important to be for public to engage and be a part of that process and also demand that information. And in fact, it is not under the mandate of the MRTP Act for MCGM to conduct public consultations prior to the publishing of the draft. But because of the public, public outcry at the point of when the ELU maps were released, there were many errors in the ELU maps in the existing land use maps. And then even subsequently, people came up with their own vision for an alternative vision for Bombay's development. So there was a series of consultations which was organized even before the final. So I'm not saying that finally all those suggestions have got implemented in the DP, but I think the process was interesting and important, and also to see how different groups engaged and came together. I think that was an interesting fact.
Thank you.
I would also like to add that when people were given the chance to participate, as I said, while drafting the 2011 Coastal Regulation Zone notification, there was a big participation and people contributed. And there are certain examples of local governments as well sharing the information, making sure people are on board. So there are different kinds of examples. It's just that we just need to be more aware and ensure that things are out in the public.
I think we'll take one last question for the session and wrap it up.
I am Varyan Murugan, I am aspirant of civil services. So I just want to ask 2 questions, one for Meenakshi and one for Matthew. The thing is, as you pointed out, there are a lot of dilution of law happening, a lot of amendments, and even some of them are without the public opinion. So on the other part, we have an announcement for our Prime Minister being a champion of Earth Award. I think these two are contradictory. So what is the view of the international community and the domestic view of this? So are we taking the award serious? The other question for the Matthew is, we have amendments for 73rd and 74th amendments for the local government. But still, for the past 3 years, we are postponing the elections, especially in Tamil Nadu, for the reasons we all know. So how to tackle as a public or as an educator, as you just want to ask. Thank you.
You asked for the views of the environmental community on the recent award being given to the Prime Minister. There have been, so we've not been able to reconcile this thing. Maybe it's some futuristic thing. If you look at the past record, it doesn't make sense. But because this government is all about future, what is going to happen in the next term, and on that guarantee only the award has been given. So
just responding to your question, and also it sort of answers. I mean, it's also a response to the question previous gentleman who asked, what should I do as a common citizen here? What do I learn from this? So
I mean, this is the basic idea of the 73rd, 74th Amendment was to have, local body elections in place, have elections, and I see that in Chennai, that's not happening, right? So one is actually, as citizens who want elected representatives to be there, to be represented as per the 73rd, as per the Constitution, right? You can actually file a case before a writ petition before the High Court of Tamil Nadu, asking for the implementation of 74th Amendment, which requires elections to be held on time, right? At least, so this has been done even in terms of Karnataka. Even then, it took a while, but it is a process where, as citizens, as a public interest litigation or any other form, you go to the court, say that, see, this is a violation of a citizen's right to be represented in the city. The city corporation is being presently run by a commissioner with no accountability to the local people, right? This is fundamentally undemocratic. This can be challenged in the court. It needs to be challenged in the court. Then the court will direct the government to do it. I do not know about the specific provisions about declaration. Is it done by SEC, that is the State Election Commission, or is delimitation done by the state government? What happens is that if the delimitation of wards and or declaring is done by the state government, they tend to delay it. Whereas if it's done by the State Election Commission, there's more accountability in it. So I'm not sure how the situation is here, but that is often the case where purposefully the state government wants to keep the local government without enough power, so that they appoint the commissioner. The commissioner just runs the show without any elected members. And I think as citizens of Chennai, you should raise this up. You should raise it up publicly. In public discussion forums, in forums like this, in the streets, or even in the courts.
Thank you. I would just like to add that even nowadays, if you see that courts are taking very popular opinions as their decisions. So it's along with the court cases, we need to have a vigil like public community who are raising issues, talking about it. We have seen that in case of Delhi trees. Because there was a large hue and cry, the courts also gave positive decisions about it. Just the courts may not work. So we need to put 2-3 different strategies together to get things out of the government.
Thank you very much, Shweta, Meenakshi and Matthew, for the very enlightening session. If you have any questions, please, you can note it down in a sheet of paper. If you're not going to be there for the successive sessions, we will aggregate them and take them together. Thank you very much.